New York has one of the most complex and restrictive tenant screening environments in the entire country. Between state-level reforms enacted in 2019, New York City's extensive local ordinances, and a deeply tenant-protective legal culture, landlords in New York face more screening restrictions than in virtually any other state. If you're screening tenants in New York, understanding the layered regulatory framework is absolutely essential. Violations carry significant penalties and enforcement is aggressive. Let's start with application fees, because New York enacted a game-changing restriction in 2019. Under the Housing Stability and Tenant Protection Act, specifically Real Property Law, Section 238AA, application fees in New York are capped at $20. That's $20 total, not $20 per screening component. The fee must cover the cost of a background check and credit check combined. Landlords cannot charge more than $20 regardless of what the screening actually costs. This $20 cap applies statewide in New York City, Buffalo, Syracuse, Albany, and every other New York community. If your screening provider charges more than $20 for a comprehensive report, you're absorbing the difference. Many New York landlords have switched to screening providers that offer comprehensive packages within the $20 cap, or they absorb the excess cost as a business expense. The $20 cap also means that landlords cannot charge separate fees for different components of the screening. You can't charge $20 for the credit check and another $20 for the criminal background check. $20 is the total maximum for the entire screening process. If the landlord doesn't actually conduct the screening, for example, if the unit is rented before the application is processed, the fee must be refunded. Landlords must also provide applicants with a copy of the screening report upon request at no additional charge. Criminal history screening in New York is heavily restricted at both the state and city level. At the state level, New York enacted significant reforms in 2019 as part of the Housing Stability and Tenant Protection Act. While New York's state-level criminal history restrictions for housing are less detailed than some cities' ordinances, the overall legal framework strongly discourages the use of criminal records in screening. New York has expanded expungement and record sealing significantly. Under CPL Section 160.59, certain convictions can be sealed after specified waiting periods. Sealed records should not appear on background reports, and landlords cannot consider sealed records. New York also automatically seals non-conviction records, including dismissed charges, acquittals, and violations that aren't crimes. Landlords cannot consider these non-conviction records in screening decisions. New York City takes criminal history screening restrictions to another level entirely. The NYC Fair Chance for Housing Act, enacted in 2024, is one of the most restrictive criminal history screening laws for housing in the country. Under the Fair Chance for Housing Act, New York City landlords are prohibited from conducting criminal background checks on housing applicants in most circumstances. The law bans landlords from searching for, inquiring about, or considering an applicant's criminal history at any point during the screening process. This is not a delayed inquiry law like D.C. or Columbus, where you can check criminal history after a conditional offer. This is a near-complete ban on criminal history screening for housing in New York City. There are limited exceptions. Landlords can consider sex offender registry status because federal and state sex offender registration laws require this information to be publicly available. And certain federally subsidized housing programs may have criminal history screening requirements that preempt the local ban. For private market landlords in New York City, the practical effect is clear. You cannot run a criminal background check on a prospective tenant. Your screening is limited to credit history, income verification, rental history, and references. This represents a fundamental shift in how tenant screening works in the nation's largest city. The penalties for violating the Fair Chance for Housing Act are significant. The NYC Commission on Human Rights enforces the law, and violations can result in compensatory damages, civil penalties of up to $10,000 per violation, and up to $50,000 for willful violations, attorney's fees, and mandatory training requirements. Outside New York City, the criminal history screening landscape is less restrictive but still more regulated than most states. Westchester County, Albany, Buffalo, and other jurisdictions have been active in tenant protection discussions, and additional local restrictions are possible. Source of income protection in New York is well established and strongly enforced. Under New York Executive Law Section 296, landlords cannot discriminate against applicants based on their lawful source of income, including housing choice vouchers, Social Security, disability payments, veterans' benefits, and any other lawful income source. This statewide protection was strengthened in 2019 and applies to all landlords throughout New York. New York's source of income protection is actively enforced through the New York State Division of Human Rights and, in New York City, through the NYC Commission on Human Rights. Fair housing testing is common. Organizations regularly send testers posing as voucher holders to identify landlords who discriminate. Landlords who state they don't accept vouchers, whether in listings, phone conversations, emails, or in-person interactions, are in violation. The practical effect is significant. Landlords must evaluate voucher-holding applicants on the same basis as market-rate applicants. If the voucher payment plus the tenant's personal contribution meets the income requirement, the applicant qualifies. Landlords cannot set income thresholds that effectively screen out voucher holders. For example, requiring that the tenant's personal income alone cover the full rent when the voucher covers a substantial portion. New York City has additional local source of income protections under the NYC Human Rights Law that provide even broader coverage and enforcement mechanisms than state law. For credit reports, New York follows FCRA requirements plus the state's additional provisions. The $20 fee cap affects how landlords structure their credit screening, but the right to pull a credit report with the applicant's consent remains intact. The applicant must provide written authorization, and if denied based on credit information, the landlord must provide an adverse action notice under FCRA. New York has an additional requirement. Landlords must provide applicants with a copy of the screening report upon request. This goes beyond FCRA's standard provision that allows applicants to obtain their report from the Consumer Reporting Agency. In New York, the applicant can request the report directly from the landlord. New York's fair housing protections under the New York Human Rights Law, Executive Law Article 15, are among the broadest in the country. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity and expression, disability, familial status, marital status, age, military status, lawful source of income, and status as a victim of domestic violence. The breadth of these protections creates a screening environment where landlords must be extremely careful about how they evaluate applicants. The domestic violence victim protection means landlords cannot deny an applicant based on their status as a victim, including police reports, restraining orders, or disruptions at a prior tenancy attributable to the perpetrator. The military status protection means landlords cannot discriminate against applicants because they are current or former military members. Combined with SCRA protections, military applicants in New York have robust protections. New York City's human rights law adds even more protected categories, including immigration status, lawful occupation, and partnership status. NYC landlords operate under the broadest set of protected categories of any jurisdiction in the country. From a practical standpoint, New York has an enormous and extraordinarily complex rental market with dramatic variation between New York City and the rest of the state. New York City is the largest rental market in the country, with approximately 2/3 of the city's residents being renters. The market ranges from ultra-luxury apartments in Manhattan commanding thousands per month to rent-stabilized units in the outer boroughs with rents well below market rate. The city's economy is driven by financial services, technology, media, healthcare, higher education, government, tourism, and virtually every other major industry. New York City's screening restrictions are the most complex in the country. The combination of the Fair Chance for Housing Act banning criminal background checks, the $20 fee cap, source of income protection, And the NYC human rights law's extensive protected categories creates an environment where the screening process is fundamentally different from anywhere else. NYC landlords essentially screen based on credit, income, and rental history, without criminal history. The rent stabilization system adds another layer of complexity. Approximately 1 million apartments in New York City are rent stabilized, and these units have specific rules governing the tenant selection process. The NYC Rent Guidelines Board sets annual allowable increases for stabilized units, and the screening process for these units must comply with both the stabilization rules and the general screening requirements. Manhattan, Brooklyn, and Queens have the highest rents and strongest demand. The Bronx and Staten Island are more affordable but have been experiencing rent growth. Each borough has distinct market dynamics, and screening approaches should reflect the specific applicant pool and rental conditions in each area. The NYC suburbs, including Westchester County, Nassau County, and Suffolk County on Long Island, have strong rental markets with high rents driven by proximity to the city. These communities are subject to state law but not NYC's local ordinances, meaning criminal background checks are permissible outside the city. However, Westchester in particular has been active in tenant protection discussions. Buffalo and Rochester in western New York have more affordable markets driven by healthcare, education, and manufacturing. These cities have experienced some revitalization but remain significantly more affordable than the downstate region. Syracuse, Albany, and the Capital District have moderate markets driven by government, healthcare, and education. The Hudson Valley, including communities along the Metro-North commuter rail, has a market influenced by both NYC commuters and local employers. The region has seen significant rent increases as remote work has allowed more NYC workers to live further from the city. Military presence in New York includes Fort Drum, home of the 10th Mountain Division near Watertown, and West Point. Fort Drum generates significant rental demand in the Watertown and surrounding communities. BAH rates for the Fort Drum area are moderate. Landlords near Fort Drum should understand military income documentation and the Service Members Civil Relief Act. One critical best practice for New York City landlords: restructure your entire screening process around the Fair Chance for Housing Act. Remove criminal background checks from your screening workflow. Do not ask about criminal history on applications, during showings, or at any point in the process. Focus your screening on credit history, income verification, rental history, and references. Train every person who interacts with applicants, leasing agents, property managers, administrative staff, that criminal history inquiries are prohibited. A single question about criminal history from an untrained staff member can generate a Commission on Human Rights complaint. Another critical best practice, for all New York landlords never state in any form: listings, phone conversations, emails, text messages, or in-person interactions that you don't accept vouchers or government assistance. Source of income discrimination is actively tested and enforced statewide. The safest approach is to evaluate every applicant based on their total ability to pay, voucher plus personal income, using the same income-to-rent ratio you apply to all applicants. A third best practice: absorb the screening cost difference created by the $20 fee cap as a business expense. Don't try to recover the additional cost through other fees or charges. This can create legal issues. The $20 cap is the law, and the most efficient approach is to find a screening provider that delivers comprehensive reports within or near that price point. For landlords operating in both New York City and other parts of the state, maintain separate screening procedures. NYC's criminal history ban doesn't apply outside the city, and the city's additional protected categories don't apply statewide. But state-level requirements, including the $20 fee cap and source of income protection, apply everywhere. Having clearly documented procedures for each jurisdiction prevents compliance errors. New York limits the security deposit to 1 month's rent statewide. This cap was enacted as part of the 2019 Housing Stability and Tenant Protection Act and replaced the prior system that allowed larger deposits. The deposit must be held in an interest-bearing account and returned within 14 days of the tenant vacating. The 1-month deposit cap makes thorough compliance screening absolutely essential. Your financial protection against a problem tenant is minimal, so getting the tenant selection right within the screening restrictions is critical. For the complete guide to New York tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.